Everyone wants to feel, think, believe that they have maximum input and control over decisions that impact their daily lives. In the area of labor management, decisions made by others can often lead to disagreements and conflict. While disputes are an inevitable part of life, they can be non-contentious, and resolution can range from consensual, maximum input negotiation to highly contentious, non-consensual, minimum input litigation. In this video, we are dealing with the last stop on the road to resolution of labor management disputes, arbitration. Arbitration occurs when disputing parties have exhausted other means of resolution and have agreed to appear before a private judge, known as an arbitrator, for a final decision. The arbitrator is not necessarily an attorney, but is usually a subject matter expert in the area of the dispute and qualified to run a hearing and render a decision. Arbitration looks very similar to a court hearing in that parties present their cases, introduce exhibits, and make arguments before the arbitrator whose ruling is final and binding. Most labor management or collective bargaining agreements that contain an arbitration procedure also include a clause that binds the parties to the decision reached by the arbitrator. One area of confusion that arises is understanding the big difference between arbitration and mediation. Often people, including the media, refer to the terms interchangeably, but in fact, they are nothing alike and should not be used synonymously. The only similarity is that both involve parties in a dispute, where a neutral third party gets involved to help them reach resolution. From there, the two processes diverge. Mediation is a voluntary process, whereby the parties make their own decisions and reach their own agreement. Mediators neither dictate outcomes nor make decisions. Rather, they help parties examine underlying issues and interests and guide them through processes toward resolution. Arbitration, on the other hand, is overseen by a person acting as a judge, who makes a final and binding decision. It is difficult to appeal or overturn an arbitrator's ruling. Federal Mediation and Conciliation Service, or FMCS mediators, are full-time federal employees and do not conduct any arbitration. On the other hand, arbitrators on the FMCS roster are private individuals and not employees nor contractors of FMCS. However, they must comply with specific FMCS policies and procedures for arbitration and follow the Code of Professional Responsibility for Arbitrators of Labor Management Disputes. Additionally, FMCS mediator services are free of charge, while arbitrators from the roster are paid by the parties requesting them, usually in equal shares, though sometimes paid by the losing party if specified in the collective bargaining agreement. The FMCS online arbitration roster includes hundreds of active arbitrators who apply to be part of the roster. The arbitration roster is maintained by FMCS as a proactive client support service to the labor management community. When one of the disputing parties makes an online request for a panel of arbitrators, FMCS will randomly select and provide the parties with an odd number of arbitrators from its roster. The randomly selected panel is tailored to the parties' requests and most often limited by specified geography. With agreement of both parties, a panel request may specify industry and/or issue experience, as well as special qualifications, such as an attorney or membership in a professional organization. Once FMCS provides an arbitration panel, the disputing parties choose their arbitrator by process of elimination. Typically, they take turns striking one name at a time until a single arbitrator remains. An alternative to this selection method is for the parties to rank order the submissions and agree on the arbitrator with the highest ranking received from both sides. In labor management disputes that have been resistant to resolution, arbitration provides a relatively even playing field that tends to be faster and less expensive than court litigation as a final and binding resolution. Originally envisioned as an alternative to potential work stoppages over a dispute, arbitration is a widely accepted process which parties almost always provide for in their collective bargaining agreement as the last step in the resolution of a grievance.